Voilà. Sandrine, les personnes sont... D'accord. Ok. J'espère qu'il m'entend. Señor Diego García Sayán, relator especial sobre la dependencia de los magistrados y abogados. Baroness Elena Kennedy, Director of the International Bar Association's Human Rights Institute. Maître François Zimret, ancien ambassadeur de France en charge des droits de l'homme. Maître Dominique Attias, première vice-présidente de la Fédération des barreaux d'Europe. Maître Pascal Maurer, ancien bâtonnier de l'Ordre des avocats de Genève et ancien président de l'Union internationale des avocats. Maître Richard Sedillo, représentant de l'Observatoire international des avocats en danger et du Conseil national des barreaux. Maître Birgit Sambeth-Glasner, vice-présidente de la Fédération suisse des avocats. Chères consoeurs, chers confrères. We are gathered here today to celebrate the 30th anniversary of the UN Basic Principle of the Role of Lawyers, adopted at the 8th Congress on the Prevention of Crime and the Treatment of Offenders in 1990 in La Habana. Before drilling into the heart of the matter, I would like to say that it's an honor for the Bar Association of Geneva to host this event. We believe in solidarity and principle, and although they should always be our watchword, we find them even more important in the face of the current situation. I would like to warmly thank the people that are present, as well as the people who are participating remotely. Wherever we may be, is this common cause and this common fight to protect our profession that unites us today. Being a lawyer means defending our clients. It means presumption of innocence until proven guilty, but it also means putting ourselves at risk for choosing to believe in those principles. Earlier this morning here in Geneva, we award the Ludovic-Trarieux to Ebru et Barkin Tiptik. I find this incredibly fitting that one of the events would take place after another, as if to remind that our profession is still in danger is still a dangerous one, in a different part of the globe. We are one of the pillars of democracy. We ensure that justice does not be influenced by politics, governments, or religious beliefs. But how we can defend our clients when our lives are put at risk? How can we practice law when our clients' rights are violated? Tout récemment encore, chers consoeurs, chers confrères, un certain nombre de nos consoeurs et de nos confrères ont payé de leur vie le juste combat qu'ils menaient pour le respect des droits élémentaires de la défense. Je pense en particulier, et je viens de la citer, à Maître Ebru Timtik, qui a reçu ce matin et qui a été honoré par le prix Ludovic-Trarieux, qui est décédé le 27 août 2020, après 238 jours de grève de la faim. Elle s'est battue jusqu'à son dernier souffle pour défendre le droit à un procès équitable et l'indépendance de l'avocat. Mes pensées vont également au bâtonnier du barreau de Port-au-Prince, Montferrier d'Orbal, assassiné devant son domicile le 28 août dernier. Malheureusement, il y en a tant d'autres. Comme le rappelle très justement le Conseil des barreaux d'Europe, bien que les principes de base aient prouvé au cours de leurs 30 années d'existence leur pertinence quant à la nécessité de protéger en toutes circonstances les droits et les obligations liées à la profession d'avocat et à la défense des citoyens, trop d'avocates et d'avocats sont encore harcelés, menacés, arrêtés, poursuivis et assassinés de par le monde. C'est la raison pour laquelle il nous est apparu impératif de célébrer, en collaboration avec l'UIA, la CCBE, l'IBAHRI, la Commission internationale des juristes, la Fédération suisse des avocats, l'Observatoire international des avocats en danger, the Law Society of England and Wales, Lawyers for Lawyers, l'Institut des droits de l'homme de l'Union européenne, la Fédération suisse des avocats, le Prix international des droits de l'homme Ludovic-Trarieux et Avocats sans frontières, ce 30e anniversaire des principes de base des Nations Unies relatifs au rôle des barreaux. Ce texte fondamental est là pour nous rappeler que le combat continue et que nous ne pouvons pas, nous ne devons pas baisser la garde. Je vous souhaite une excellente conférence.
Chers consoeurs, chers confrères, mesdames, messieurs, la Fédération suisse des avocats que je représente aujourd'hui est totalement engagée en faveur des principes de base relatifs au rôle du barreau. The basic principles on the role of lawyers are indeed key to guarantee and set in motion the fundamentals for free, independent and proper functioning of the legal profession. And in turn, the Professional Association of Lawyers, and amongst them the Swiss Federation of Lawyers, are key to guarantee and set in motion those principles in their respective jurisdiction. Accordingly, our associations have a vital role to play in upholding professional standards and ethics, protecting their members, as we have heard before, from persecution and improper restriction and infringements, providing legal services to all in need of them, and cooperating with governments and other institutions in furthering the end, the goal of justice and public interest. Professional associations like the Swiss Federation of Lawyers and lots of associations represented today also have to promote the access to lawyers and legal services through programs to inform the public about their rights and duties under the law and the important role of lawyers in protecting their fundamental freedoms and in enabling them to assert their rights. More so, professional associations of lawyers ensure that lawyers have appropriate education and training, and that they're fully aware of the ideals and ethical duties of the lawyer and of human rights, and of fundamental freedom recognized by national and international law. Professional association of lawyers shall prevent discrimination against a person with respect to entry into or continued practice within the legal profession on the ground of race, color, sex, ethics, origin, religion, political or other opinion, national or social origins, property, birth, economy, and other statutes. Last, self-governing professional associations exercising their functions without improper external interference are key to represent the interest of lawyers, protect their professional integrity, while doing so, enabling lawyers to counsel and assist their clients in accordance with the law and recognized professional standards and ethics. Mr. Vice President of the Council of the State, Mr. President of the Bar, Mr. Vice President of the Bar, all very distinguished guests and all representative of these very important professional associations which have been listed just before. Last but not least, all participants of this incredible organizing committee of the event of today. Dear friends, the Swiss Federation of Lawyers, a member of the CCBE, composed of all 26 bar associations of Switzerland, representing more than 11,000 lawyers of the various linguistic, geographic, and structural tendencies, all registered at the Cantonal Bar in Switzerland, is, since a long time, committed to apply, defend, promote, and fully live the basic principles on the role of lawyers. You can count on us, you can count on the Federation, and we will continue doing so. In the name of the Federation, the Swiss Federation of Lawyers, and in particular of Maître Albert Nussbaumer, our president, who is unfortunately prevented to assist today, I am very happy and deeply honored to celebrate this utmost important anniversary, and hope that we will live up to all those principles and be part of the helping in the society to have those principles really applied. Thank you.
Monsieur le bâtonnier, mesdames et messieurs, en vos titres et fonctions, permettez-moi de vous souhaiter une chaleureuse bienvenue, tant au nom du Conseil d'État de la République et canton de Genève qu'au nom de la ville de Genève. Je voudrais tout particulièrement remercier l'Ordre des avocats de Genève d'avoir pu organiser cet événement, de même que les organisations partenaires, la Fédération suisse des avocats, l'International Bar Association, l'Union internationale des avocats, la Commission internationale des juristes, l'Observatoire international des avocats en danger, la Law Society of England and Wales, Lawyers for Lawyers, l'Institut des droits de l'homme de l'Union des avocats européens, le Prix international des droits de l'homme, Ludovic-Trarieux, le Conseil des barreaux européens, Avocats sans frontières. Je suis particulièrement fier de pouvoir m'exprimer aujourd'hui devant vous à l'occasion de ce jubilé important, qui dépasse certainement, ici en Suisse, vu depuis la Suisse, l'importance qu'il a réellement à travers le monde, et un événement comme celui-ci nous permet de nous rappeler ce que peut être le quotidien des avocats à travers le monde. Cela nous permet de faire une pause, de prendre un peu de recul, après 30 années depuis l'adoption de ces principes de base relatifs au rôle du barreau, de voir à quel point, depuis 1990, lorsqu'ils ont été adoptés à La Havane, les choses ont pu évoluer. Elles ont certainement évolué, mais il y a tant à faire encore. Je voudrais saluer aussi l'opportunité de rendre hommage à celles et ceux qui, aujourd'hui encore, trop nombreux, se battent pour assurer la mise en œuvre de cet outil et s'engagent parfois au risque de leur vie, risque qui parfois malheureusement se réalise, pour défendre l'état de droit et le respect des principes. Vous l'avez relevé, dans certains pays, récemment, la Turquie et en Iran, des avocats ont perdu leur vie pour tout simplement faire leur travail. Il nous appartient de rappeler l'importance de préserver les fondements de l'exercice de la profession d'avocat, l'indépendance, hors de toute ingérence étatique, et le secret professionnel, seul garant de la confiance du client. La place qu'occupe Genève et la Genève internationale tout particulièrement dans le domaine des droits de l'homme, notamment grâce au Conseil des droits de l'homme qui tient actuellement sa 45e session, donne toute sa légitimité à ce lieu pour réfléchir et faire un point de situation. Je veux ici souligner l'engagement actif du canton en faveur des droits humains, notamment via son service de la solidarité internationale, compte tenu de l'intervention, je crois savoir, en vidéoconférence de M. Diego Garcia Sayan, rapporteur spécial de l'ONU sur l'indépendance des juges et des avocats, je peux ici rappeler la collaboration avec la Commission internationale des juristes, la CIJ, et l'appui apporté par le canton de Genève au Geneva Forum on Judges and Lawyers, que la CIJ organise chaque année depuis maintenant 2010. Le canton de Genève, à travers le Fonds de la solidarité internationale, soutient, sans doute y a-t-il encore beaucoup à faire, mais soutient néanmoins le projet développé par la CIJ dans plusieurs États pour garantir l'égalité d'accès à la justice dans les systèmes judiciaires traditionnels et étatiques. Voilà, mesdames et messieurs, je voudrais vous remercier, vous, public, pour votre intérêt, souhaiter aux organisateurs, aux personnes qui participent et aux panélistes, que ce soit en présentiel ou en visioconférence, une rencontre qui soit inspirée et surtout inspirante, riche en débats et en idées. Je vous remercie toutes et tous pour votre engagement.
Good morning, ladies and gentlemen. Monsieur Philippe Cotier, président des ordres d'avocats de Genève, Madame Birgit Sambet-Glasner, vice-président de la Fédération suisse des avocats, Monsieur Mauro Poggia, vice-président du Conseil d'État de Genève. Ladies and gentlemen, and dear representatives of the organizations that have promoted and sponsored this event. Dear colleagues and friends, I am really honored by this invitation from the Geneva Bar Association to share some views as a special rapporteur of the UN in this anniversary of the basic principles on the role of lawyers and on the crucial role of the members of the legal profession as guardians of the rule of law. My deep appreciation as well to the prestigious organizations that have joined the Geneva Bar Association in organizing today's events, which have been already mentioned by my predecessors, and I adhere to that mention. Lawyers play a vital role in the protection of rule of law and human rights. It is the responsibility of lawyers to protect and establish the rights of citizens from whatever quarter they may be threatened. Their work, as we all know, is indispensable for ensuring effective access to justice for all. But so do opponents of the rule of law, the promoters of authoritarianism, of justice at the service of particular interests, and of impunity of corruption and human rights violations. Around the world, lawyers are harassed, threatened, attacked, or worse, for simply doing their job. In this regard, the basic principles whose 30th anniversary we commemorate here are a fundamental human rights tool that we do well to remember and reaffirm. In October 2018, I presented before the General Assembly my report highlighting the essential role that lawyers, and especially bar associations, play in a democratic society, and how crucial is the legal profession in upholding rule of law, promoting human rights, and ensuring access to justice. Bar associations have an especially relevant role in a democratic society, protect individual members, requirements and procedures to gain access to the legal profession, codes of professional conduct, disciplinary procedures, and to cooperate with the state institutions in rule of law matters. As you all are perfectly aware, free exercise of the legal profession and the protection of human rights are closely interconnected. This is clearly reflected at least in three major issues. First, access to a lawyer. The right to have access to a lawyer first constitutes an integral part of due process and a fair trial that has been established in a large number of UN instruments, including the basic principles on the role of lawyers and, of course, the Universal Declaration in the International Covenant on Civil and Political Rights. Second, legal assistance to be effective has to be carried out independently. as is established in the preamble of the Basic Principles. Adequate protection of human rights and fundamental freedoms requires that, quote, all persons have effective access to legal services provided by an independent legal profession, unquote. Third, free establishment and functioning of bar associations. They are crucial. Lawyers, among other rights, are entitled to freedom of expression and association. The basic principles recognize that lawyers, like other citizens, have the right to form and join self-governing professional associations to represent their interests and perform a variety of functions. Among others, facilitating access to a lawyer and legal services, Principles 3 and 4, promoting the continuing education and training of lawyers, Principle 9, regulating non-discriminatory access to the legal profession, Principle 10, protecting their members from persecution and improper restrictions, Principle 25, adopting and enforcing codes of professional conduct, Principle 26, handling disciplinary procedures against their members, Principles 28 and 29. However, while we commemorate today this 30th anniversary, the legal profession is under threat or attack in many parts of the world. Turkey and Iran properly have been mentioned now. Recent arrests of 48 lawyers in Turkey add to a consistent pattern that began in that country after the attempted coup in 2016, with arrests, prosecutions, and convictions of members of the legal profession and judges in a massive scale. In October 2017, I made an official visit to Poland and reported to the UN the situation in terms of the independence of the judiciary and of the legal profession, which were both and are under attack. Attacks, however, may come not only from governmental authorities like the countries that have been mentioned, or eventually Hong Kong. I will give an example from other parts of the world. A couple of years ago, the National Judicial College in the United States conducted a survey and asked its student body, all of them judges, if they felt that judicial independence was being threatened. More than 90% of those judges responded yes, and an extremely high 64% even identified various specific threats, such as false or misleading media reports, attacks on judges on social media, recall elections triggered by unpopular rulings, coercive budget cuts from the executive and legislative branches, just to mention some of them. The majority of those U.S. judges also mentioned that, I quote, "the threat comes from the same group that threatens the core of our democracy, individuals with large sums of money who in the past have used their money to purchase the legislators or their vote, are now using their money to influence judicial rulings from those who stand for re-election or retention," unquote. Similar extended and deep threats and challenges are being placed to independent judges and lawyers around the world. The current wave of violent extremism sweeping across certain parts of the globe is certainly having a profound impact on basic democratic principles and guarantees. This is turning societies less sensitive to, and perhaps more tolerant of, restrictions on due process, limitations on human rights guarantees in criminal proceedings, the expansion of security and intelligence measures, and potential abuses of authority in the name of national security. This environment has created challenges to uphold the line between permissible and impermissible infringements on basic human rights and lawyers' ability to represent their clients without external interference or pressures and without undue encroachment on the principle of legal professional privilege, professional secrecy. The principle of legal professional secrecy has come under threat where governments pass legislation that mandates disclosure of confidential client information. Lawyers are often forced to act as agents of the state by disclosing private and confidential client information, sometimes without the permission of their unsuspecting clients. However, regarding all these aspects that constitute major threats against rule of law, the voice of organizations such as those arranging today's celebration sounds strong in every corner of the world. It comes into my mind what happened in Pakistan back in 2007. There was an ongoing battle for an independent judiciary, which flared up in the so-called Black Coat protests, in which well-dressed lawyers took to the streets in response to the government's suspension of the Chief Justice of Pakistan Supreme Court. Even though the protests escalated, in the end, they were known as the Lawyers' Movement, they succeeded in having the Chief Justice reinstated. We have also witnessed the activism of the members of the Turkish legal profession, which in the worst circumstances are defending publicly and publicly denouncing a series of threats and backlash against lawyers and judges. Last year, Lawyers for Lawyers, together with 151 other international and domestic bar associations, other lawyers organizations, and legal professionals from 49 countries around the world, called on the government of the Philippines to take all necessary measures to stop the attack against and extrajudicial killings of judges and lawyers, and to end the culture of impunity in which these attacks were occurring. The independence of the judiciary and the legal profession are fundamental pillars of a democratic society. Independence is not provided for the benefit or protection of lawyers or judges as such, nor is it intended to shield them from being held accountable in the performance of their professional duties and to general law. Instead, its purpose is the protection of the people, affording them an independent legal profession as the bulwark of a free and democratic society. Professional independence is both a duty and a privilege because it serves as a guarantee of due process for the public. Fundamental democratic principles such as the separation of powers and the core principle of judicial independence would not have much meaning in the absence of an independent legal profession entrusted with the duty of assisting the courts as an instrument in the administration of justice, an officer of the legal system, and a co-minister of justice. Dear colleagues and friends, lawyers and bar associations have a crucial role to play in a democratic society, in defending judicial independence and the function of the judiciary around the world. May this commemoration of the basic principles serve to reinforce existing efforts to affirm the rights of society to have access to a legal profession that can function with guarantees and freedom. My congratulations for the organization on today's event. Thank you very much, ladies and gentlemen.
Thank you, Mr. Special Rapporteur, for your time and your kind words. I don't know if there are questions in the public. No, I don't think we have any from our virtual audience, but I have one just for you. What do you think that as Geneva lawyers or as European lawyers we could do to help our fellow lawyers who are in danger elsewhere? What in your opinion you think is effective?
With details, with objective information, what is happening in the most sensitive situations in countries. And second, disseminate this information promptly, broadly, and address the local and national authorities systematically. I think that creates a situation in which what can be done from bodies like the UN would be much stronger, much more consistent and efficient. The UN system works in a way very slowly. The possibility to react, to act and follow up is very limited for the limited human and institutional resources. So I think that the bar associations, the associations of bar associations may play a really relevant role to address systematically one case, repeat the information regarding the same case, and of course, public awareness through the media so that the people don't forget what is happening there. I remember what has happened with the 48 lawyers that were detained in Turkey some days ago. Well, there was some information for a couple of days, and nobody, not too many people are now remember what happened with them, what questions must be raised, what questions should be transmitted to the Turkish government. To give only an example, there's no obsession with Turkey, but this is a most recent and scandalous case. So I think bar associations can play a fundamental and systematic role. Thank you for the question.
Thank you. I think we can now start with our next panel, where we have the opportunity to hear from very courageous lawyers all over the world. So I leave the floor to Marc Jory and Marie Berger, who's just joined us. Thank you. Thank you, Mr. Rapporteur.
Thank you. Maître Marie Berger, who just came from court,
yes,
where she
exactly.
was allowed to practice her trade and her profession freely. And I are very honored to host the first panel of, and to have been invited to do so by the Bar Association of Geneva. We have a panel of 3 very distinguished lawyers who are very much involved on the ground with the issues that we have to deal with and the ways to uphold the principles that are so precious to us. The 3 lawyers that we will be hearing from are Carolina Villadego-Burbano.
From Bogota.
From Bogota, exactly.
Colombia, bienvenida.
Bienvenida. Ayşe Bingöl Demir from Turkey, and Margaret Ngoyee from Hong Kong. So, Carolina, I will first introduce each of the panelists, and then we'll hear from each of them. And during their presentations, you're all invited within the audience here and at home or at work, for those attending the conference, to pose questions, which we'll be happy to relay to the panelists afterwards. Carolina is a Colombian lawyer, as I said, and she has a master's degree from the University of George Washington, so she's familiar with the free system, and she has focused her professional experience on justice systems and their connection with human rights in Latin America and in developing advocacy strategies on these fields. She has participated as a teacher in some universities, especially on topics related to the justice system functioning, and she has issued many publications dealing with the corruption of the judicial system in her country, in her home country, the multi-thematic approach to reforming the justice systems in Latin America. She will also speak not only about Colombia, but about other countries in Latin America. And she has also worked with several institutions that are much involved in the advancement of the UN principles, including the Ombudsman Office of Colombia, the Justice Studies Center of the Americas, and the Center for Law, Justice and Society Studies, de Justicia. And she's currently counsel for Latin America of the International Commission of Jurists, and is also currently part of the board of directors of de Justicia.
Maybe just 2 words about the situation in Colombia, maybe to remind that extrajudicial killings and enforced disappearance did not stop after the agreement of peace of 2016, at the contrary even. And in addition, it seems that the creation of new institutions by the peace agreement have changed some basic rules and procedure for the investigation and prosecution of those crimes. So consequently, the Colombian justice systems appears, but you will confirm or not, Carolina, to be maybe today more complicated to understand, and this not only for the victim, but obviously for the lawyers also. We have some elements from the actuality coming from Colombia. We heard about, for example, maybe the Restrepo collective case with this revelation of the massive illicit surveillance of communication, including communication between lawyers and clients. So we are really eager to hear you, Carolina, about the situation in Colombia, and maybe also about the situation in other countries of Latin America you know well. Thank you very much.
You have the floor.
Thank you, Marie and Mark. Good afternoon to everyone in Geneva, and good night and good morning to my other colleagues around the world. Thanks to the Geneva Bar Association for inviting me to participate in this event. My intervention will address some progress and challenges in the implementation of the principles on the role of lawyers from South American perspective. So first, I will want to mention that from a Latin America regional perspective, it is important to mention that the UN principles have been recognized by the Inter-American Court of Human Rights in the Castillo-Petrucci versus Peru case in 1999, and by the Inter-American Commission of Human Rights in their landmark report about guarantees for the independence of the justice operators in 2013. This is important as it shows the relevance of the standards set out in the principles and the relevance given by the inter-American bodies with the regional oversight, which have a regional oversight over the countries. Now, from a national perspective, let me address some of the progress and challenges and some of the principles. I will first begin with the principles related to security of lawyers, as there are some challenges, especially in countries where there is a breakdown of the democratic institutions and the rule of law, as Venezuela, or where there is armed conflict, as Colombia. Just to give an example and related to some of the things that Marie was mentioning before, last May, just recently, many lawyers that represent victims in a macro case of extrajudicial killings that is being heard by the Special Jurisdiction for Peace in Colombia, asked the jurisdiction for precautionary protective measures due to security risk, harassments, and profilings by intelligence institutions. So there has been a deteriorating situation regarding the protection of lawyers that represent victims of serious human rights violations in the country, and also when cases are relevant due to political implications. Having said that, let me address another set of principles. Regarding principles relating to access to lawyers and legal services, especially the one that address the right of all persons to have the assistance of a lawyer of one's own choosing, and the having access for free assistance. There are some progress in South American countries that I want to mention. But first, national legal frameworks have recognized the right to defense and to the assistance of lawyers of one choice. During the last decades, and especially since the implementation of the adversarial criminal system in most of the countries of South America, there has been a strengthening of public defense system, especially in criminal matters, and you can see a strengthening of public defense in Colombia, in Chile, in provinces of Argentina, and other countries. Also, usually this public defense system provides free assistance for persons under vulnerable conditions, for example, in Colombia, and Argentina, and Chile, and Peru. Yet, in some places, the free assistance is only provided for persons that can't afford a public defender. Some of the public defenses institutions provide legal assistance for accused and for victims in criminal cases. Now, on that set of principles, let me mention a couple of challenges that some countries still faces. So first, there is still a gap between the right to have a lawyer and the right to have a lawyer of one's own choice, especially in criminal matters, and especially when persons are deprived from liberty, as many of those cases are assisted by public defenders, and there's no room for persons to choose the lawyer. This is a more complex situation when the organization of public defenses in some countries, organize the work by shifts or by procedural stages, so one accused can have a couple of lawyers during the complete procedure. This issue is, for example, addressed in Colombia, in Brazil, and in Argentina. A second set of challenges here is about there's still a gap between the actual public defense service that is provided in the country versus the real public defense services that are needed in the country, considering all persons that are in a disadvantaged position. So it is clear that even though there has been a strengthening of public defenses, the public defense system has less resources than the judiciary or the prosecution, but the real question here is, does the public defense system have the resources they need to participate fulfilling the principle of equality of arms in the process? That is something that has to be analyzed, for example, in Colombia and in Peru. Also, a last challenge regarding these kind of principles is related to the gap between the concentration of public defense in larger cities or urban centers versus the providing the right to provide a lawyer and public defense for persons that are located in rural areas or far away from larger cities. It has been identified in Colombia, in Argentina, and in Brazil. To all of you that are interested about all these topics, there is a report that is called Effective Criminal Defense in Latin America that was launched in 2015 and that is available in English too. Let me pass quickly to two other principles that I want to mention in the implementation. So for example, regarding Principle 8, related to the need to provide adequate opportunities to communicate and consult with the lawyer when the person is under arrest, there are still some challenges. For example, in Brazil, public defenders usually met the accused right before the custodial hearing with law enforcement agents present. So there's no real preparation of the defense before that custodial hearing or private communication. And in Argentina, there's evidence that shows that some persons that are deprived from liberty do not meet with their defender. Finally, regarding, for example, the principles related to the duties of lawyers toward the clients, there are some challenges that I want to mention, especially related to the need to respect the interests of the clients. For example, when the person is from indigenous community. As most of you know, there are many indigenous communities in many countries of Latin America, and there are a variety of native languages. So one of the main challenge here is that there is, and where is room for improvement, is in cases where accusers do not understand the language used by the courts or by the lawyers, and they not only need interpreted, but sometimes the procedure still is conducted in Spanish and Portuguese, depending on the country, and the person that do not really understand it. So just to give a final thought, as I have said, there has been progress in the implementation of the principle, but there's still a long way to go. It is important to remember that in some countries, lawyers are under attack and states are failing in their obligation to protect them and to ensure the integrity and role of the legal profession. Thank you.
Thank you very much, Carolina. We would like to invite the public to ask questions if there are any right now or later at the end of the discussion. There is a question, I believe, here.
Thank you very much for your presentation. I have a question regarding, in particular, the lawyers in Latin America who defend environmental cases or cases of the indigenous land, and we have the knowledge that are in particular threatened. I was wondering, what were the challenges, as the threatening party is in general a company, a private person and not the state, but maybe the state plays a role in the impunity of these cases. Thank you.
Thank you very much for your question. You're absolutely right. There is a threat to lawyers that are defending human rights, especially associated, for example, not only to serious human rights violations, but also in context of mining projects and larger environmental situations. I think we all need to encourage the protection of lawyers and the protection to address the risk security that they really have, and to ask sorry,
yes?
to ask yes, to ask the governments to ensure that the independence of the lawyers is guaranteed in the countries, and that the protective measures are really in place. Thank you.
Thank you. Any other questions at this stage?
I have maybe a question, Carolina. I don't know if it's still the case, but I've always heard that in Colombia, the lawyers are not all together in one national bar association, and that there are a lot of division between lawyers. For example, the lawyers active in human rights, and maybe the lawyers doing more business. Is it still true? Is it a problem because then maybe you cannot express as lawyers some request and oppose maybe to some action? What's the situation now?
In Colombia, there's no mandatory obligation to be part of a bar association. So being part of a bar association is voluntarily. There are several bar associations, and there are many lawyers that exercise the profession that are part of those bar associations. So I think we still have a lot of independence of the profession and independence of what lawyers do in every single subject matter. So some of them are litigators, some of them are researchers, and so on. What is also a fact is that the legal profession has also disciplinary procedures, and the disciplinary procedures are being analyzed by a special chamber in what is now or was before the Judicial Council. It is under a change in this moment, but it is on that. So it is true there's no mandatory bar association here.
Thank you very much. I would like to invite our next panelist, Dr. Margaret Ngoyee. And I must say, as a way of introduction, that we're humbled to have you among us today, because you have lived in the flesh the violation of the very basic principles we are here to celebrate and to determine how we can improve the way of upholding them in the future. You're an alumni of Cambridge University. You have been called to the bar in Hong Kong in 1988, and you have had also a life in the academia at the University of Hong Kong, from what I understand, as well as in the financial world before getting back to the legal profession. You have been involved in very high-profile cases which have led to judicial review of the situation and of the integrity of the basic law that was adopted in Hong Kong after the separation from England, from the Great Britain. In 2003, you have formed the Article 23 concern group in order to deal with the respect of all of these measures. And you have also, in 2008, co-founded the Civic Party, a political party with the specific aim of presenting candidates that would be guided by the very basic principles that we are talking and discussing today. You have also been involved in advocacy groups in order to bring to life the new generation and to get them to be educated with respect to the democratic and human rights values that we are trying to impose in Hong Kong. And finally, you also co-founded the 612 Humanitarian medical and legal assistance and help with legal representation with respect to the many cases that have been spewing in Hong Kong. Finally, I would like to add that on top of all of these hats, you are also very versed in philosophy and you have practiced journalism, so we're eager to hear from you with respect to the situation in Hong Kong, which is a very rapidly moving situation, and to tell us also about the latest events that have concerned you. I understand that you suffered an arrest in April of 2020 of this year in connection with 15 other very high-profile figures in Hong Kong. So thank you very much for being with us, and you have the floor.
And thank you more, because it's in the middle of the night, I think, in Hong Kong. So really, thank you for being with us.
Thank you for asking me. I'm very sorry to have given you such a long CV. That's because of my age. You're quite right that too many things are happening too fast in Hong Kong, and lawyers are being kept very, very busy indeed. I'd like to mention just a few. Let's say 3 things. First of all, Hong Kong is paying hugely for her fight for freedom. Since the mass protests last June, already more than 10,000 people have been arrested. Just over 2,000 people are being prosecuted. They are facing trial, and many of them will be facing prison, and many of those facing prison will be for years in prison. And so this is a very dire situation. Also, the public sees that the police use of violence is not being restrained. Many of the defendants appear in court in very poor shape indeed, with bones broken and sometimes in a wheelchair. And this is not being addressed. And so the public feels that justice is not being done. Prosecution is not, policy prosecution is not even. This is a source of great grievance, and sometimes the court system or the decision of the court, the process which the defendants go through, have become controversial. And so we have a very severe crisis in the rule of law. This is one thing. The second thing is, since 1st of July this year, a national security law had been passed in China to apply in Hong Kong. These add very serious criminal offenses, which are defined in very broad terms, and they add new restrictions to freedom of speech, freedom of assembly, of association. And the worst thing is that the consequences are very severe, and so you have uncertainty and creating anxiety. So that ordinary speech in Hong Kong, we are used to a great extent of freedom. So in demonstrations, all sorts of slogans are being chanted, and suddenly many of these slogans become criminal, and you may be liable to arrest. And once you are arrested under the national security law, the threshold for bail is a lot higher. Thirdly, the national security law says that it overrides local Hong Kong law. That means it challenges the basic protections that we have learned to expect from the common law. We are now seeing a kind of the national security law taking over from the common law, from the local law system. But we hope that at least the national security law is under the basic law, and in the basic law there is a protection, a clause of protection of human rights under the International Human Rights Conventions, and this is preserved in the national security law. Although how that the two things can work together, that on the one hand you use very clear terms to restrict freedom, and on the other hand you say that you are nevertheless protected by the International Human Rights Conventions, and that also adds insecurity to the whole situation in Hong Kong. The national security law is very different from the law that we are used to. If the protests starting last June had been very widely broadcast, so I don't have to go into the details. But what set it off was a proposal of amendment of the law whereby persons in Hong Kong may be surrendered to the mainland of China to be dealt with under the Chinese criminal justice system. And the difference, and the reason why Hong Kong people are very worried about this is that the two systems are different. As I said, in Hong Kong, we have had 150 years of colonialism, and the one legacy that we treasure from the colonial era is the common law and the rule of law. And so we are not about to give that up. But the difference in the mainland system is very stark, as may be illustrated by the recent news of 12 Hong Kong people who tried to run away from Hong Kong and were intercepted by the mainland's marine police, and they are now detained in Shenzhen, which is the part of the mainland of China. And their access to a lawyer of their choice, as Carolina had been talking about, is extremely different. Their families in Hong Kong have engaged lawyers for them, but apparently these lawyers cannot have access to them. They are being represented, we are told, by government-designated lawyers. So this highlights the difference, and it makes Hong Kong people even more determined that they want the system that they are used to. The third thing that I'd like to refer to is that now there seems to be a systematic attack on the judiciary. Recently, there is a very strange debate on whether there is a separation of powers in Hong Kong. And that is not just an idle discussion, because it's followed by a very severe attack on the judges and a very distressing and deafening silence from the government in defending the independence of the judiciary. The Chief Justice of the Court of Final Appeal had to issue a statement of 13, 14 pages just yesterday to set down all the principles governing judicial independence. So all these things are exercising our attention. So all these things are keeping our lawyers very busy. Hong Kong lawyers who are committed to the defense of human rights have an important duty there, both to, as to normal duties, defending the rights of their clients, but in abnormally difficult situations. When you have one client, that is the duty is normal. But when you have massive people arrested, sometimes the most distressing situation is when you have a public demonstration and then suddenly hundreds of people are being arrested. So that is the point when they need most someone to, a lawyer to represent them, to watch over their interests for them. And so this is the quantity and also the delay of trial because, of course, of the coronavirus. And that also added to the distress. So we have had to mobilize hundreds of lawyers to be on the watch so that when people are arrested, they would have very quickly be able to get a lawyer. And sometimes we complain very bitterly about the denial of access or the delay of access, particularly in the context of police violence. Sometimes there are a lot of very credible complaint that they were mistreated or ill-treated when they are in custody. And it's credible when you see your client coming into court in a wheelchair. And so this is the kind of situation we have to provide enough legal support for these hundreds and thousands of arrested people and defendants. Then secondly, we also have abnormal duties, I shouldn't say abnormal, that doesn't sound good. I should have said unprecedented task of finding a way to preserve the rights and liberties we enjoy under the basic law and reconcile that under the national security law. Because whether we like it or not, the national security law is a law which is being applied to Hong Kong. And we have to find a way to see how this national security law nevertheless can, what should I say? Nevertheless, we have to read that in the context of the protection of human rights. And that takes very deep learning and senior lawyers taking up these cases. We have already a couple of them to see whether the national security law, although written as a Chinese law, can be interpreted by using common law principles. And this is being done. And I have found the efforts very admirable, but it's not enough. So looking forward, there are a great deal of work to do. I don't know to what extent we are up to the challenge, but I feel sure that the Hong Kong Bar will rise to the challenge, not only in court, but also in public, because we have to explain to the public what the law is about, what they face, and how they can protect their rights and freedoms. At the same time, of course, when lawyers do that, they expose themselves to risk, not because, fortunately, we are not yet arrested as lawyers defending clients, but no doubt by making ourselves, calling attention to ourselves, we become more vulnerable. But I'm afraid this is something that we have to put up with, and I hope that we will continue to persevere in this task, because we have no doubt that this is our duty and it is our privilege to be able to rise to the occasion. Thank you very much. Thank you.
Thank you, Dr. Ngoyee. Your words are really inspiring, and from here, as you said earlier, all of these events have been broadcast, and so we are aware, but from here it looks all the time like China's mainland government is stifling Hong Kong slowly but surely. What you have told us about how the fight is being waged is indeed very inspiring. You mentioned earlier that the common law heritage is a treasure, and you have given us an example of how that common law heritage is being put to use to fight the effects of those laws imposed by the mainland's government. So I would say that, contrary to what I had expected, your words are encouraging and uplifting, and the situation is not as much as it's dire, it's not as desperate as one could think. Is my assessment correct, or am I being too optimistic?
Oh, we are very desperate indeed, but it wouldn't do to concentrate on desperation, because the counsel of despair is often the worst. So I think it is part of our colonial heritage, a stiff upper lip, isn't it? I think this is what it is called. But I think that one thing I do feel truly consoled, comforted by, is the determination of the young end of our bar, that they have put so much optimism and so much dedication into their job. Continuity is very important. I mean, our task is very difficult because China has an absolutely different political and legal culture. And so when our culture, the legal culture we are used to, which is free and open, and their political culture, which is, a lot of it is on authority and control, you can see that we have a very hard time. But thank you very much for your good words.
Thank you. Thank you.
Maybe one question, Margaret. If I well understand, but you will correct me, you are now having cases that you are contesting with arrestation linked to the national security law, I mean. And is there a possibility that you bring the case until the Supreme, the last court in Hong Kong, and this court could, applying common law, say that this national security law is or is not valid, applicable? Is that something you could expect, a decision from the highest court in Hong Kong?
I think it would be rather a tall order to say that the national security law is not valid. However, what does different clauses and provisions in this national security law mean? How should it be applied? There is room for discussion. And there is no doubt that our courts have to interpret even the national security law by common law principles, because under the basic law, which is our constitutional basis, the Hong Kong courts only have authority to apply common law principles when they interpret the law. And so here is your room. I think our senior lawyers are studying the situation to reduce the threat of this national security law. Because on the face of it, the national security law says that if there is any inconsistency between a local law and national security law, then the national security law takes precedence, which seems to be that our whole system is being trumped. So we're going to narrow that down so that we can still protect our most fundamental freedoms.
Thank you. Would there be any questions from the audience? Yes.
I'm sorry, my assistant reminds me that nevertheless, that the national security law states that national security, the NPC, the National People's Congress Standing Committee, has the power to interpret the national security law. So you see a bit of competition there.
I would also remind everybody attending the conference virtually that they are most welcome to submit questions by Zoom. We will be able to relay them to our panelists.
But we have one question now.
Yes.
Thank you.
Thank you, Margaret, for your determination. We are very lucky here as Swiss lawyers to be in a quiet country. How can we help you? What do you expect from us?
And as always, when people fight for their freedom, they have to stand up for themselves. But it is always good and encouraging to know that people in other parts of the world know about it and support us and understand, and that we are not alone. This is the most important thing. And also because we are a member of the common law community, your understanding of the common law, your experience in defending basic rights and freedoms will always inspire us. So if I may put it in very simple language, in fact, in 2 words or 3 words, that is, keep in touch.
Would there be any other questions at this stage? If not, I invite Marie to introduce our next panelists.
Hello, I say Bigel Demir is a lawyer specialized in international human rights and domestic law and procedure in Turkey. She's graduated from Istanbul University Law Faculty and Queen Mary University of London, where she obtained a LLM in human rights. She practiced in Istanbul during years, it means between 2003 and 2017, and she was involved particularly in cases concerning serious violation of fundamental rights and freedom. She represented many lawyers in the criminal proceedings targeting their legitimate professional activities, and she has part of the international campaign for lawyers' rights. We all heard about it. IDHAE was in 2016 awarded for the CCBE Human Rights Award jointly with other lawyers from Turkey, 3 other lawyers. Congratulations, IDHAE. She worked with a Media Legal Defense Initiative, and she was a research fellow with Middle East University School of Law between 2017 and 2020. She was also part of the group of experts that conceive of the London-based Turkey Human Rights Litigation Support Project, and she has been acting as a co-director since the beginning of the project. It was in 2018. Currently, she's based in New York, and she also works as a non-profit consultant and country expert for several national and international civil society organizations. So we are eager also to hear you, I say, about obviously the terrible situation of the lawyers in Turkey, and also maybe to understand what could be the meaning of the principle of the principles of the UN in a country as Turkey today. Thank you very much.
Thank you very much, Marie. Thank you, Mark. I would like to thank Geneva Bar Association and other co-organizers for facilitating today's discussion on the current challenges to the legal profession in the context of 30th anniversary of the UN Basic Principles. One of the things that makes that event very special to us is the announcement that was made at the beginning of the event that our colleagues Ebru Timtik and Barkan Timtik have been awarded with Ludovic-Trarieux Human Rights Prize. And it is a privilege for me to take part in this event when this award was announced today and be together with these distinguished members of panelists, colleagues, and also a panel consisting of my fellow women colleagues, Margaret and Carolina. During the session, we will be discussing the practical challenges lawyers face while practicing in our respective countries. We heard from Margaret and Carolina about the practices in their own countries and regions. And I must admit that it was very difficult for me to decide on what matters to talk to you today, taking that in Turkey, persecution of lawyers have been taking many different forms. But during my presentation, I will try to briefly reflect on the UN Basic Principles and what this important instrument means for us. Then I will share my comments on the situation of lawyers in Turkey. But due to the time limits, I will have to keep my focus on the arbitrary use of criminal proceedings against lawyers. The UN Principles on the role of lawyers is a fundamental document for us lawyers to carry out our professional activities freely. And it derives its logic from the fact that in democratic systems, lawyers and bar associations play a vital role in ensuring effective access to justice, protecting individual rights and freedoms, and securing the principles of rule of law. And this public watchdog role lawyers and bar associations take in the establishment of justice requires lawyers to benefit from the guarantees stipulated in the basic principles. Domestically in Turkey, the constitutional principles around human rights and the statutes of bar associations and provisions in the law on lawyers are generally in line with the UN principles, especially before the recent amendments made in the law on lawyers to change the structures of bar associations in Turkey. Basically, these laws and protections recognize that lawyers are independent in their functioning of their professional capacity. Lawyers are one of the constituent elements of the justice system in Turkey, and the bar associations have the right and obligation to involve in matters on human rights and rule of law. An important challenge we lawyers and human rights defenders have in Turkey is the fact that the laws are not always the source of violations. It's the practice which has been followed seriously. We all know that proper implementation of laws and international obligations depends on a proper implementation by the state institutions and an effective judicial oversight. And the good faith of the state institutions is very important. And the judiciary needs to be independent and impartial. There is no doubt that the increasingly authoritarian regime in Turkey, which has been completely undermining human rights and rule of law principles, has been exerting serious influence on the judiciary, while also showing no hesitation to openly interfering with its conducts. It's important to note that these structural problems in Turkey are not new to us. But in the last few years, we have been experiencing one of the worst periods in the context of human rights and democratic standards in the country. I would like to now turn to the arbitrary use of judicial actions and criminal proceedings against lawyers and bar associations, which in my view is one of the most serious tools utilized to intimidate lawyers in Turkey. Intimidation of lawyers by criminal proceedings in 1990s and in 2000s was dominated by the security state policy adopted against the context of ongoing armed conflict between PKK and the Turkish security forces. The most recent pattern of intimidation takes its basis from this and also the July 2016 coup attempt. As many of you already know, following the coup attempt, the government declared a state of emergency and have adopted an increasingly hostile attitude towards lawyers who work on human rights violations and systemic rule of law issues, and those who represent persons charged under anti-terror laws. Turkish officials, including the President and the Minister of Interior, and pro-government media regularly target these lawyers and bar associations, labeling them as terrorists and public enemies before any court decision confirming the guilt. The prosecutors influenced by this discourse have been launching criminal investigations arbitrarily against lawyers and bar associations immediately after such statements. The lawyers targeted by the governments are continuously intimidated through arbitrary arrests, detention, imprisonment, and ill treatment. They are prosecuted, often convicted based on vague definition of terrorism and related acts. In these proceedings, lawyers in Turkey are often identified with their clients and their clients' causes and prosecuted based on who they represent. As indicated by the Council of Europe's Human Rights Commissioner, the judiciary in Turkey completely ignores the professional relationship between lawyers and their clients. They consider lawyers to be associated with the terrorist organizations their clients are accused of being a member of. There are many examples of these practices which have been observed by several organizations and colleagues who are present here today. In November 2011, for example, more than 46 lawyers were arrested because they were representing Abdullah Öcalan, the imprisoned head of PKK. In January 2013, 12 progressive lawyers of Progressive Lawyers Association and People's Law Office were arrested, many detained. Among them were Ebru Timtik and Barkın Timtik. In March 2016, 11 lawyers from Association of Lawyers for Liberty were similarly arrested, many detained due to their work on the rights of minorities, Kurdish rights. In September 2017, a second operation was carried out against Progressive Lawyers Association and People's Law Office. Similarly, many were arrested, later detained. Ebru Timtik, Aytaç Ünsal, and Barkın Timtik were among them. I represented many lawyers in these proceedings when I was practicing in Turkey, but due to the time limitations, I will just refer to the reports of the international observers and monitoring mechanisms on these proceedings. No need to say that this pattern is still ongoing. Recently, on 11 September 2020, reportedly 48 lawyers were arrested. On 21st September, 27 lawyers were arrested. And 6 of lawyers of the previous operation that also was mentioned by Mr. Special Rapporteur were detained on remand yesterday. They were all being charged with similar offenses of being affiliated with Gülenists based on their representation of clients accused of similar offenses. The questions asked to lawyers during the police interrogations clearly show the reason behind the arrest, how many clients they represent, what types of cases they are involved in, if they have any formal agreement with their clients, how much money they charge, and how many cases they have. To conclude this part, I would like to borrow a line used to describe for situation of journalists in Turkey. With hundreds of lawyers currently in prison based on unlawful charges, I think that we can easily say that Turkey has long been one of the leading jailers of lawyers in the world. And what impact this widespread pattern of judicial actions against lawyers have? In combination with other issues, including, for example, the physical attacks, harassment, ill treatment, and impunity, and legislative restrictions put in place to limit lawyers' access to cases, their clients, and privileged communication of lawyers, and the recent law change made in the law on lawyers to divide the strong voice of bar associations against the wrongdoings of the states, the impact on the lawyers' community have been serious. It seriously diminished the lawyers' ability to properly represent their clients, take up certain cases, and be involved in human rights cases. It created a chilling effect, preventing other lawyers to take up similar cases. It was against this extremely challenging background that in January and February 2020, our colleagues Ebru Timtik and Aytaç Ünsal started a hunger strike. Their demand was legitimate. They requested the government to cease the problematic practices and the authorities to respect and protect fair trial rights. On 5th April 2020, on the Lawyers' Day in Turkey, they turned their hunger strike into a death fast. Lawyers, NGOs in Turkey and abroad collaborated and carried out many activities, but the lack of response from authorities in Turkey resulted in Ebru's passing on 27th August 2020. A deeply devastating event for us. We still mourn for her loss. Sorry. And today, together with you, I think that we should. It's a very special event that to hear that Ebru and Barkın has been given that prize, and the struggle of Ebru and other lawyers in Turkey has been recognized in that way. So I thank you for the jury, the committee, which decided on that. And we will be hearing a lot about the other struggle of other lawyers in other parts of the world. And we know that there are other ongoing hunger strikes, including the one that is still continuing by Nasrin in Iran. And I think that we do not want to lose any other colleagues to this struggle. And we need to think carefully as lawyers community on what to do. Thank you very much.
difficult to talk after you, I say, but just one question. What can we do to help you and your colleague in Turkey?
Thank you. So I was going to share a few comments on that, but I was out of my time, so thank you for answering that. So it is a difficult question, but I will try to share a few reflections through my work on this matter. I think that we all know that the Council of Europe is continuing its work on drafting a convention on profession of lawyer. This instrument is, if concluded, with an effective monitoring mechanism in place, will be an important tool to strengthen the rights of lawyers, I think. And with many organizations and exceptional colleagues here, we have been carrying out collective work to raise awareness to the situation of lawyers, not only in Turkey, in other countries. And I find this collaboration very important. I think it needs to continue and to be communicated to the outside world, especially to people who have policy-making powers or having and monitoring powers on the countries more. And I think that through my work, especially currently, what I think is soft diplomacy in some countries doesn't work. And Turkey is at this stage right now. Maybe you have followed. A few weeks ago, the president of the European Court of Human Rights visited Turkey. It was a diplomatic visit, of course, but it was criticized a lot. Soon after he left the country, the Nationalist Party, the coalition member of the government, proposed to adopt that penalty again in Turkey. And this was supported by the chair of the parliament, from whom the President Spano met during his visit. And lastly, relevant to that, a strong appeal before the international monitoring mechanisms is needed, a firm and strong appeal. Individual applications to monitoring mechanisms, by that I mean to European Court of Human Rights or the UN Committee on Human ICCPR Committee. The individual applications are important, but they have their own limitations in addressing serious and systemic human rights violations. In that sense, I think that we need to campaign for an interstate application against Turkey or other countries that serious and systemic violations are ongoing and the states are not complying with their human rights obligations. And this for Turkey could include the systemic and serious human rights violations concerning fair trial rights, prevention of torture, arbitrary arrest and detention of oppositions, including lawyers, right to freedom of expression, peaceful assembly and free elections. Such applications to address this deteriorating pattern will certainly have an impact on today's government, as it was the case in the interstate applications made in 1980s and 1990s. So these are a few of my reflections on your question, Ali.
And maybe just one more. We are always thinking about this. If some of our action are maybe at the contrary counterproductive, it means it could worsen the situation of our colleague in Turkey or in other country. Is it the case sometimes? Not really.
I think that it depends on who you collaborate in Turkey. And if the case has such sensitiveness, I am sure that people who you collaborate on the ground would let you know. We did do that few times when the cases were so delicate and we thought that an action might be counterproductive, as you said. There can be cases, so I think that it's important to keep it in mind and discuss it openly with whom we work with from Turkey to discuss about potential implications.
Aisha, you touched earlier upon the fact that the government identifies the lawyers with their clients or their clients' causes, and I believe that this goes to the heart of the negation of the essence of what a lawyer is and what a lawyer's trade is. And what do you think can be done at the grassroots level to eradicate this belief, obviously not against the, I mean, the governments are lost cause in that respect, but from the ground up on the educational level, what do you think, what steps can be taken so that slowly but surely the consciences arise to that reality, that lawyers are not their clients, and are not to be identified with their clients nor their clients' causes, but on the contrary, they have to be in a position to carry out their profession independently?
It is an important question. I think this requires a proper human rights education, starting from a very early age in the countries like Turkey and elsewhere, because when people are just filled by government's official narratives through their education from very beginning, dehumanizing, marginalizing others, human rights defenders, lawyers, who are in their mind working against the state's officials, official practices, policies, and being defined as public enemies. Therefore, it has an impact from the perception of lawyers public. So a proper human rights education, starting from very beginning, is very important. But I am afraid in countries like Turkey, this has to come from the government, because it's very hard for the civil society or lawyers to have that wide ranged action. But it could be something that could be done. We get involved, hopefully.
Civil society. Would there be any questions from the audience to Ayşe? I believe that is not the case. So I would really would like to thank three wonderful ladies, Carolina, Margaret, and Ayşe, for having shared with us your experiences and having given us the honor of participating in this conference. And I would like to invite Miriam and Adrien to host the second panel, which will dwell on the role of associations for the purposes of upholding those basic principles. Thank you very much.
Thank you very, very much, the three of you.
So good afternoon, everyone. We are very pleased to host the second panel today with Adrien related to the role of the Lawyers Association. And so we are going to hear Baroness Helena Kennedy, the bâtonnier Pascal Morer, who is together with us today, and Maître Richard Sedillo. We'll briefly present the three panelists, and maybe we will ask the question at the end of the three presentations. So we'll have some more interactive discussions, if that works for everyone. So to start, Baroness Helena Kennedy is a British barrister, member of the United Kingdom's House of Lords, who held many prominent positions throughout her career, including, among many others, Chair of the Justice, the British arm of the International Commission of Jurists, Bench Chair of Gray's Inn, Chair of the Human Genetics Commission, and Chair of the British Council. She also chaired the Power Inquiry, which reported on the state of British democracy and produced the Power Report in 2006. She has authored and published several books on the ways in which the justice system fails women. Baroness Kennedy is also director of the Institute for Human Rights of the International Bar Association. Good afternoon, Lady Kennedy, and thank you very much for being with us today.
It's a great honor and privilege to be here, and thank you for that very warm introduction. And let me say to all of you that although I've held a number of different leading positions in organizations, the thing that I'm proudest of in my life is that I've been a practicing lawyer in the courts. I've spent over 40 years in the courts defending in very difficult trials, usually of a political nature, and we even do have those in Britain. We went through the Irish Troubles, and I acted for many people who were charged with terrorism. And I went through a whole period of acting for cases involving the Middle East. I've acted in many cases involving national security. So I just wanted to say that even in a place like Britain, there are times when human rights lawyers are necessary. My role now at the International Bar Association is that I run the Institute of Human Rights. And it's important that you know that the IBA, the International Bar Association, which is celebrating an anniversary too. It's not just the UN that's having a 30th anniversary concerning lawyers and the wonderful basic principles which the UN created 30 years ago. But at the same time, the IBA also created a set of standards for lawyers and for bar associations, and we're celebrating that anniversary in conjunction with you. And I'm just sorry that we can't all be together and that we weren't all able to be together in Kyoto in order to make a real festival of celebrating the importance of this, but also to remind the world that lawyers matter. And I wanted to start by saying that we're all in the circumstances of facing a contagion, the terrible business of the pandemic and COVID-19. And it's keeping us all apart, which is a great source of regret to me, because there's always so much more energy in a room or in a place when we're together. But it's also a time where there's another contagion afoot, and it's the growth of populism. It's the growth of a rejection of many of the things that we know are vital to liberal democracies in the world. And I say with pride liberal democracies, because I believe that democracies have to be about more than simply the voting of people. We know that democracies, and one of the pillars of any decent civilized society, is respect for the rule of law. And that does not mean just that law is passed by Parliament. It means something much richer and more meaningful. And it does mean the independence of the judiciary. One of the forgotten pieces of that business of the rule of law is that it also means independent lawyers. Independent lawyers are fundamental. If lawyers can't act for people and are not traduced for automatically being an avatar, somehow as reflecting the attitudes and views of their clients, then you're in trouble. And unfortunately, the media and social media today frequently attacks lawyers, making assumptions about lawyers and failing to understand what professionalism really means. And we're seeing a deprofessionalizing of the professions. And we should be concerned about the impact that has on decent democracies. Now, the IBA brings together huge numbers of lawyers from around the world, but it also brings together 187 bar associations. And it takes great pride in saying that it helps nations establish bar associations. Unfortunately, there's a great variety in what people think a bar association is about. And in some countries, the Bar Association is nothing more than a way of lawyers coming together in order to network or acting as a trade union in some way. And they don't perform the function that we would be imagining a bar association should be performing in the protection and safeguarding of lawyers within its national boundaries and even beyond. And there are lots of bar associations around the world, unfortunately, that don't do that. They've never known, because they haven't had the experience of knowing that being independent from government is one of its functions, and that hasn't been built into their experience. The other thing is that sometimes bar associations are captured. They, because of the authoritarianism of a state, they become basically the puppet of government, and they will do the bidding of government. So you have bar associations which are active, which protect their lawyers, which are independent, which are critical of law that is bad law, which are critical of erosions of judicial independence. But you also have bar associations which just remain silent in the face of all of those things. You also have bar associations that, worse than that, actually do the bidding of governments. And we've just been dealing with it just now at the IBA, at the Human Rights Institute that I deal with, where one of my own advisory council, a member, Beatrice Matetwe in Zimbabwe, has had their practicing certificates suspended so that she cannot act in court. And the Bar Association has done that. And you know that it's at the bidding of those that are in power. And it's because she's been taking up the cases of journalists who are critical of the state. She's been taking up cases of activists who are critical of government corruption. And when you do those kinds of cases, unfortunately, you are in the sights of oppressive governments. And if you don't have a bar association that's brave enough, it will fold in the face of the pressure that comes from an authoritarian state. And unfortunately, there are places that call themselves democracies today that are, I'm afraid, surrendering the rule of law and trying to create compliant judiciaries and also going after lawyers who act in cases where it might be acting for journalists, acting for civil society activists, acting for those who are for students and protesters over certain aspects of governance. And what we're seeing is an assault upon the very embodiment of the rule of law. And so I take this opportunity to, first of all, pay tribute to the lawyers that we've just heard from, who are really at the front line. Margaret Ngoyee, a great and close friend over many, many years, as she says, she's done a lot of things because she's older, and I'm in the same category, and that's why we've been friends for so long, battling on about the importance of law in sustaining democracies in the face of threat. And she has been a great champion of that. And has to be careful about what she says because of this new legislation that has been brought in. Because if you seem to be encouraging outside complicity and undermining, then you can find yourself before the courts. I also wanted to talk about Turkey, because we've been undertaking trial watches in Turkey just now, also trying to give support to the lawyers there. We've been doing it in relation just now in Belarus. We've got 2 lawyers who've been arrested in Belarus, Ilya Salier and Maxim Znak. And so we know this is part and parcel of what's been happening. And in too many places, we're seeing lawyers assaulted, under attack, jailed, put before courts with trumped up charges, accused of things in relation to national security, which becomes a coverall for fake prosecutions. And so the question that always arises is, what do we do? I had an exchange recently with someone where I said, I feel that sometimes we make interventions, we do trial watches, we do reports, we have task forces, we have all manner of activity. And you feel that these people who are ruling in many countries and in places where we had hopes for democracy, in places which we thought were established and mature democracies, where we're seeing the erosion of law. And how one can start thinking that everything one does is without results. And I know that my friends who are rapporteurs, and the wonderful Diego, who I listened to earlier from the audience, sometimes you wonder if it's going anywhere. And all I can say is we have to keep believing that it does matter, because it provides solidarity to those who are suffering. So those of us who are sitting comfortably in Geneva, or who are living in places where, however difficult things might at times be, they're nothing like as bad as they are in many parts of the world. We owe it to our colleague lawyers. We owe it to the rule of law. we owe it to our belief in democracy and our belief in human rights to basically keep on doing what we do, which is providing solidarity, making interventions, making those statements, giving those press releases, and making the reports. But for practical purposes, I wanted to mention two things. We at the IBA have created a toolkit for lawyers at risk. And we did that in coalition with the UN, and we went to work on it, and it's now something that we're doing workshops on, and it's available to anybody. And we've had it translated just now into French, so it should be available in many places. We're having it translated into Russian. We're having it translated. And it doesn't solve, toolkits don't solve everything. The tools alone are not good enough. But if you know to whom you can turn when you feel under threat, if you're a lawyer practicing somewhere where you don't have a bar association that's going to come to your aid, to know that there are places to which you can turn, that there are lawyers' organizations, that there are ways in which you can take steps, and that there are international laws that you can invoke, which will challenge the state, your national state, which might be undermining your role as an independent lawyer. The other thing I think that we've got a duty to do is to challenge the media, because too often we see this business of lawyers being conflated with their clients, of an undermining of lawyers who are doing the difficult cases and who are acting for people who are considered to be enemies of the state and who then themselves are called enemies of the state. So we really do have to make sure that the media are called to account. And I wanted finally to say, I want to encourage everybody to have Magnitsky Law introduced into your countries. Magnitsky Law is about being able to have targeted sanctions against people who let these things happen, so that heads of bar associations can be called to account, or ministers of justice, so that when they come to visit Geneva, or when they come to visit London and New York, that their assets are going to be frozen, that they're not going to get visas, and that we have to make sure that there are ways in which we give teeth to international law. So I pay tribute to Diego Garcia Sayan, who is a great champion for us as lawyers. And I say to everybody, none of us can say we haven't got a role to play. We do. And I say to the three women we've heard from today, you have our lasting admiration for your courage in the way that you take stands, and we want to be here for you. Thank you.
Well, thank you very much, Baroness Kennedy. As Miriam explained, in this panel, we will hear each speaker before we take questions. So here is a few words about le bâtonnier Pascal Maurer, who graduated from the University of Geneva in 1973 and immediately started his career as an attorney in Geneva. Today, he remains active in criminal and civil litigation as a partner in the law firm Kepler Avocats in Geneva. Among many other accomplishments, Pascal Maurer was president of the Geneva Young Bar, member of the Geneva Bar Association's Council, president of the Geneva Bar Association. On an international level, Pascal Maurer was member and then president of the European Bars Federation, on top of which he's been an active member of the International Association of Lawyers, UIA, for 25 years now. Member since 1995, president of the UIA's Commission Defense of the Defense 1998 to 2001, member of the Board of Directors from 2001 to 2008, vice president from 2008 to 2009, elected president then until 2010, then president until 2011, and general director of UIA's Institute of the Rule of Law since 2015. Monsieur le bâtonnier Pascal Maurer, nous vous remercions et vous donnons la parole.
Merci beaucoup. Je vais parler français pour rétablir un peu l'équilibre dans les discussions. J'espère que vous me comprenez tous et j'espère que ça ne gênera pas ceux qui sont en vidéoconférence. La question qui nous est posée, c'est quel est le rôle des associations internationales d'avocats ou des associations nationales d'avocats? Alors, pour vous dire la vérité, c'est une question que je me pose depuis que j'ai cessé de m'occuper activement des droits de la défense et des interventions au plan national ou international en faveur de ces confrères qui nous rappellent, lorsqu'on parle d'eux ou lorsqu'on entend parler d'eux, quelles sont nos racines. Les racines que parfois on a oubliées, les racines dont on est éloigné parce qu'on est pris dans notre travail de tous les jours et qu'on a nos soucis généraux, personnels, actuels. Nous avons des avocats dans le monde qui risquent leur vie pour rappeler ce pourquoi nous sommes faits. Défendre les autres, même à notre propre risque. Après des années que j'ai passées, à m'occuper justement de faire des appels, de mobiliser les gens, je me suis posé la question, et c'était un moment de faiblesse qui, Dieu merci, est passé ce matin, ça sert à quoi? Ça sert à quoi quand on voit qu'il y a de plus en plus de pays qui ne respectent pas les principes de la Havane? Quand on voit que les principes de la Havane qui ont été adoptés en septembre 1990 ou 90 pour parler suisse, à l'unanimité des pays présents, ont été adoptés par des pays qui n'ont pas dit un mot, qui n'ont pas protesté, parmi lesquels, si vous prenez la liste, il y avait la Chine, la Colombie, l'Égypte, l'Iran, la Pologne, l'Arabie saoudite, la Syrie, la Turquie, la Malaisie, l'Ukraine et l'URSS. Tous ces pays, aujourd'hui, presque tous, ignorent les principes de la Havane. Et on est là pour leur rappeler qu'ils les ont signés ou qu'ils les ont adoptés. Même silencieusement, ils étaient présents, ils n'ont pas protesté. Aujourd'hui, si l'on pense à la Turquie, nous sommes là pour faire en sorte, comme nous avons décidé de le faire ce matin pendant que nous parlions du prix Ludovic-Trarieux, nous sommes là pour leur dire, vous avez signé, vous avez adopté, vous devez respecter. Et si, comme le disait personne pour qui j'ai une grande affection, une grande admiration ce matin, si nous baissons les bras, comme parfois il me vient l'envie de le faire, si nous baissons les bras, nous leur donnons raison. Parce que si nous ne réagissons pas à leur violation, alors ils auront gagné. C'est pour ça que nous sommes là, les associations internationales d'avocats ou les associations nationales d'avocats, pour toujours avoir quelqu'un qui reprendra le flambeau quand ceux qui sont plus âgés ou plus aînés, comme moi, parce que maintenant je commence à atteindre par la limite d'âge, ont un peu tendance à baisser les bras, et pour nous redonner du courage. Alors nous sommes là pour dire à ceux qui se battent que, comme disait Margaret Ngoyee tout à l'heure, we have to keep in touch. Il ne faut pas les oublier, il faut qu'ils sachent que nous sommes là et nous pensons à eux et nous les aiderons autant que nous pouvons. Nous sommes là pour aider leurs familles. Nous sommes là pour faire des appels. Récemment, l'Union internationale des avocats que je représente ici, qui est la première organisation internationale d'avocats créée au début du siècle passé, pour dire, qui a adopté les principes pour la défense de la défense en 1987 déjà, dans lesquels elle faisait le rappel des principes essentiels et notamment de ceux qui consistent à ne pas confondre les avocats avec leurs clients et à reconnaître aux avocats le droit d'être indépendants et de parler librement sans risquer leur propre vie. L'Union internationale des avocats a fait un appel à l'action en faveur des principes de la Havane, jointly avec l'International Bar Association et la Japan Federation, qui a été signé par 50 barreaux, à peu près. Barreaux nationaux ou barreaux internationaux, Association internationale d'avocats, et qui a été présenté récemment à la session du Conseil des droits de l'homme de Genève au mois de juillet de cette année, et qui a été rappelé dans la résolution que le Conseil national des droits de l'homme a prise, en disant « Nous prenons note que les barreaux sont là pour défendre les principes de la Havane qu'il faut continuer à défendre. » Et ce qu'il faut faire, je pense, c'est continuer à travailler ensemble, ne pas travailler les uns à côté des autres et parfois même les uns contre les autres. Nous avons besoin de nous unir et de chercher des nouveaux moyens de travailler. Seuls, comme avocats, nous n'avons pas assez d'influence vis-à-vis des gouvernements. Ce sont les gouvernements qui peuvent faire quelque chose. Nous devons alerter nos gouvernements. Nous devons appeler la presse à nous aider. C'est la presse qui sera notre voix quand nous pourrons parler, quand nous dénonçons des cas de violation des principes de la Havane, d'harcèlement d'avocats, de meurtre d'avocats. Nous devons en parler à la presse locale, en demandant que la presse locale le fasse savoir au public. Parce que nous n'avons pas le moyen de faire savoir au public ce qui se passe dans la profession d'avocat dans le monde. Et pour que la presse, à son tour, fasse une pression sur les gouvernements, parce que les gouvernements réagiront sous la pression de la presse, et demander à nos gouvernements, comme je l'ai entendu tout à l'heure, de prendre des mesures sérieuses qui soient à même d'amener les pays qui ne respectent pas les principes de la Havane et les droits des avocats et les droits de la défense à changer d'attitude. Et ce matin, en participant à la délibération du jury du prix Ludovic-Trarieux, j'ai repris espoir. Je me suis dit, effectivement, il faut continuer. Il faut surtout pas baisser les bras. Il faut défendre ces avocats admirables et il faut que nous joignons tous nos efforts pour arriver à faire passer les messages que nous devons faire passer. Voilà à quoi servent les associations internationales d'avocats. Voilà à quoi servent les associations nationales d'avocats. Ça être la voix de ceux que l'on veut faire taire et être la défense de ceux qui ne peuvent plus se défendre eux-mêmes. Merci.
Merci infiniment, Monsieur le bâtonnier. So our next panelist is Maître Richard Sedillo. So briefly, Richard Sedillo is a French lawyer who mainly practices private international law and international criminal law. He has pleaded cases in many countries, notably before special criminal courts, in political trials, or in the interest of defendants facing death penalty. He is currently Vice President of the European and International Affairs Commission of the Conseil National des Barreaux, spokesman of the association Together Against the Death Penalty, and represents the Conseil National des Barreaux at the International Observatory of the Endangered Lawyers. He is regularly consulted by international organizations as a human rights expert, such as for the UN or the Council of Europe. Richard Sedillo is very often invited to speak at international conferences in relation to human rights and defense. Good afternoon, Richard, and thank you very much for being with us today.
Thank you. Thank you very much, Miriam, and thank you to our friend from Geneva who did organize this very, very interesting conference. I am sorry, as the bâtonnier Morer, I will speak French. I think it's important to use both languages, French and English, on these occasions. Je suis vraiment très heureux d'être là et j'ai trouvé les interventions de tous les panélistes particulièrement intéressantes. Je me sens évidemment particulièrement modeste et comme le disait une panéliste qui est intervenue avant moi, lorsque nous intervenons au soutien de nos confrères en danger, nous ne devons jamais oublier que nous regagnons, après nos interventions, le pays dans lequel nous exerçons à peu près librement, alors que les confrères que nous assistons, que nous tentons d'aider, continuent, eux, et nous avons parfois tendance peut-être un peu à l'oublier, à faire face à un danger constant, pour eux-mêmes d'une part, mais également et souvent pour leur famille. J'en dirai un mot, mais je pense à cet égard notamment à notre consoeur Nasrin Sotoudeh, dont vous connaissez le tragique destin et dont je viens d'apprendre qu'après une brève hospitalisation, elle vient malheureusement d'être renvoyée en prison. Je pense à elle parce que, au-delà du sort particulièrement cruel qui lui est réservé, vous avez peut-être appris que sa fille elle-même avait été menacée et qu'il s'agissait évidemment pour les autorités iraniennes de faire pression sur notre consoeur, pas uniquement directement, mais également au travers de ceux qu'elle aime. Les dictatures sont malheureusement de plus en plus imaginatives et nous avons tous le sentiment que nos confrères menacés sont de plus en plus nombreux. Bien sûr, l'information est probablement bien meilleure aujourd'hui qu'elle ne l'était il y a 10 ou 20 ans et les réseaux sociaux contribuent à cette meilleure information. Nous avons tout de même le sentiment, et à la lecture du remarquable annuaire qui est préparé chaque année par l'Institut des droits de l'homme des avocats européens, sous l'égide notamment du bâtonnier Favreau, on se rend compte qu'il n'est plus aujourd'hui possible de dénombrer ceux de nos confrères qui, à travers le monde, subissent la pression de pouvoirs politiques dictatoriaux. Alors on pourrait considérer évidemment que les atteintes qui sont portées à la défense sont le plus cruel, mais aussi le plus remarquable hommage qui est porté à la profession d'avocat. Car si notre profession n'était pas aussi remarquable, aussi importante dans la défense des libertés, on peut imaginer que les dictateurs ne s'y intéresseraient pas d'une façon aussi avide. Le courage de nos confrères nous oblige, et comme le disait le bâtonnier Maurer, si nous devons conserver tout l'optimisme qui est le nôtre, il est vrai qu'on peut toutefois s'interroger sur les moyens dont nous disposons, qui sont souvent, malheureusement, extrêmement insuffisants. Et pourtant, et au travers de quelques exemples dont je vous parlerai très brièvement, je pense qu'il y a des raisons d'espérer. Je me souviens des interventions de nos barreaux, de nos associations, à l'époque de Ben Ali en Tunisie. Vous vous souviendrez de tous ces avocats qui étaient poursuivis dans des conditions absolument dramatiques, enfermés, menacés, dont les familles l'étaient aussi. Tous nous disaient, lorsque nous allions assister à leur procès, les choses sont tout de même considérablement différentes lorsqu'un observateur étranger est là. Et le pouvoir n'ose pas tout de même donner toute la dimension de sa cruauté lorsque des avocats français, allemands, italiens, anglais se déplacent pour assister au procès dont nous sommes nous-mêmes victimes. Nous rencontrions déjà à l'époque en Tunisie une difficulté toutefois qui tenait à la possibilité pour un avocat étranger d'intervenir devant les juridictions tunisiennes. Parce que c'était le cas notamment pour les avocats français, la convention franco-tunisienne permet à un avocat français de défendre un ressortissant français en Tunisie et réciproquement pour un avocat tunisien en France, mais en revanche, rien ne permettait à un avocat français de défendre un ressortissant tunisien en Tunisie. Nous avions donc évidemment invoqué tous les instruments internationaux protecteurs des droits de l'homme pour tenter de justifier le libre choix de l'avocat. Mais on se rendait bien compte tout de même qu'il existait une limite et que les principes de la Havane, j'en reparlerai rapidement, ne constituent pas un instrument international suffisamment contraignant pour être opposé d'une manière efficace aux États qui veulent faire taire la défense. Mais ce premier exemple était tout de même porteur d'espoir, même si le sort réservé à nos confrères était extrêmement cruel. On voyait bien tout de même que l'observation internationale pouvait être de nature, en partie, à changer les choses. Je pense à un procès absolument étonnant auquel j'avais participé en Mauritanie, procès qui était organisé en plein milieu du désert par le dictateur de l'époque qui avait décidé d'organiser la condamnation à mort de 40 opposants politiques. Je ne vais pas entrer dans les détails, mais le président de la Cour m'avait dit lorsqu'il m'avait accueilli, c'est très gentil d'être venu, mais moi on m'a mis là en me demandant de prononcer 40 peines de mort, donc quoi que vous fassiez, vous les avocats étrangers, je prononcerai 40 peines de mort. Finalement, notre présence et le fait que nous ayons pu dénoncer les conditions dans lesquelles ce procès se déroulait, notamment aux chefs d'État européens qui ont fait pression sur la Mauritanie, et ce fut le cas notamment du président Chirac, ont permis de sauver tous ceux qui allaient être condamnés. Pourquoi je parle de ce procès, au-delà des accusés qui encouraient la peine de mort? C'est tout simplement parce que ce procès mettait aussi en danger ceux de nos confrères qui assuraient la défense des accusés. Et ils souhaitaient la présence d'observateurs, évidemment et en tout premier lieu pour les accusés, mais également pour se protéger eux-mêmes d'une espèce de vindicte dictatoriale qui pesait sur l'opposition politique, mais également sur le barreau. Je pense à notre confrère Margaret Ngoyee, que certains d'entre vous connaissent, qui est un avocat un avocat congolais de RDC particulièrement courageux qui a rédigé un rapport sur les couloirs de la mort au Congo. Autant vous dire que ce rapport, évidemment, n'a pas eu l'heure de plaire aux autorités congolaises. Un procès inventé de toutes pièces a alors été organisé. L'idée était de le condamner pour une faute assez vénielle, mais pour obtenir ensuite sa radiation du barreau. Nous sommes allés le défendre, un confrère parisien et moi-même, et tous les confrères qui étaient présents nous ont dit « ce n'est pas notre qualité à nous qui nous sommes déplacés qui était importante, n'importe quel avocat européen aurait fait l'affaire. Nos confrères congolais nous ont dit « votre présence a considérablement changé les choses ». Et Liévin n'a jamais été condamné parce que nous avons pu dénoncer les conditions dans lesquelles il est être jugé. De sorte que, vous voyez, cette présence tout de même peut être de nature parfois à changer les choses et qu'il faut garder espoir. Je pense à notre consoeur Lydienne Eyoum, que beaucoup d'entre vous connaissent. Je vois Dominique, mon ami Dominique Attias dans la salle, qui connaît bien Lydienne. Lydienne Eyoum est une consoeur camerounaise qui a été mise en détention pour un dossier qui n'avait trait qu'au paiement d'honoraires. Il s'agissait donc d'un litige qui relevait exclusivement de la compétence du bâtonnier. Elle a été placée en détention parce qu'on voulait l'interdire d'exercer, bien évidemment. Le barreau français et le barreau suisse, car Saskia Dittisheim, qui doit être là aussi, a fait partie des avocats qui ont assuré sa défense avec beaucoup d'efficacité. Saskia a fini par, Lydienne, pardon, joli lapsus, a fini par sortir de prison. Elle a été invitée par le Conseil national des barreaux et elle a fait une intervention extrêmement émouvante. Elle a décrit les conditions de détention absolument épouvantables qu'elle a connues au Cameroun. Et elle a terminé son intervention en nous disant « Si le barreau européen n'avait pas été à mes côtés, et si je n'avais pas su au fond de mon cachot que vous étiez là à me soutenir, aujourd'hui, je peux vous le dire, je serais morte. Je n'aurais pas survécu au sort qui m'était réservé si je n'avais pas conservé cet espoir que conservent, vous savez, les otages lorsqu'ils savent que, au-delà des frontières du pays dans lequel ils sont détenus, il y a des gens qui pensent à eux, qui luttent pour eux. On ne le fait pas toujours avec l'efficacité qu'on souhaiterait. On n'obtient pas toujours les résultats escomptés. En tout cas, pas toujours aussi rapidement qu'on l'espère. Mais ce soutien permanent est aussi une manière de permettre à ceux qui souffrent de tenir encore. Et ce témoignage avait été extrêmement émouvant et il nous a été rapporté par plusieurs confrères. Continuez, quel que soit le résultat et quelle que soit l'heure du résultat, continuez à nous soutenir car sans vous, nous ne pourrions pas survivre. Je pense évidemment à nos confrères turcs dont on a parlé, dont le courage nous émeut et nous honore. C'est vrai que malgré une observation permanente au procès, c'est vrai que malgré la présence d'avocats de très nombreux pays européens notamment, la répression se poursuit et les arrestations de confrères par dizaines, extrêmement récentes, sont de nature à nous inquiéter. La situation serait peut-être encore pire si nous n'étions pas là, et je pense que cette humanité, cette fraternité porte aussi le combat de nos confrères turcs et les aide aussi à poursuivre dans la voie du courage qui se sont fixés. Ils sont très heureux que nous soyons là, et même si ce bonheur peut paraître dérisoire au regard de la situation qui est la leur, je pense tout de même qu'il ne faut pas lâcher, qu'il faut poursuivre toujours, ne serait-ce que par respect du combat qui est le leur. Et puis je pense évidemment à l'Iran, parce que, comme d'autres, comme beaucoup d'autres, je passe actuellement beaucoup de temps à m'occuper notamment de Nasrin Sotoudeh. Vous connaissez cette consoeur condamnée une première fois à 5 ans de prison, alors qu'elle n'avait pas été autorisée à pénétrer dans le tribunal au motif que le voile qu'elle portait était d'une couleur trop chatoyante pour satisfaire les juges. Quelques années après, elle est arrêtée de nouveau, notamment pour avoir pris la défense de jeunes femmes qui refusaient de porter le voile, et elle va être condamnée à plusieurs peines pour un total de 33 années d'emprisonnement et 148 coups de fouet. Elle est notamment condamnée pour incitation à la prostitution, car les mollahs ont estimé que le fait de défendre une femme qui refusait de porter le voile constituait une incitation à la prostitution. C'est dire tout de même si la loi est particulièrement dévoyée. Le Conseil national des barreaux a décidé, vous le savez peut-être, d'installer son portrait sur l'intégralité de la façade de l'immeuble boulevard Haussmann à Paris. Le barreau de Paris a affiché son portrait, le barreau de Marseille l'a fait tout de suite. Nombreux sont les barreaux qui sont intervenus au soutien de la défense de ses intérêts. Et la notoriété qui est aujourd'hui la sienne, probablement, est en partie de nature à la protéger d'une certaine façon. En tout cas, plusieurs confrères iraniens nous ont fait dire que si les coups de fouet n'avaient pas été donnés à Nasrin, c'est peut-être parce qu'elle a acquis aujourd'hui une notoriété que la défense qui lui a été procurée par un certain nombre de barreaux a été de nature à lui a donné. Que peut-on faire pour Nasrin? Nous avons introduit avec le Conseil national des barreaux, l'association Défense sans frontières et l'Observatoire international des avocats de la défense, un recours devant le groupe de travail sur la détention arbitraire de l'ONU. Nous espérons très prochainement introduire un second recours en son nom, mais également au nom d'autres confrères iraniens qui sont détenus dans des conditions épouvantables. Le recours est prêt. Nous attendons simplement l'accord des autres confrères iraniens qu'il est évidemment très difficile de joindre, notamment parce que certains d'entre eux ne sont pas détenus à Téhéran et l'un d'entre eux est même malheureusement maintenu au secret. Le mari de Nasrin Sotoudeh nous dit « La seule chose qui peut la sauver aujourd'hui, c'est la pression internationale. Il n'y a pas d'autre solution. » Les autorités iraniennes ont fait pression sur certains détenus pour les convaincre de se taire, en leur disant « Si vous ne parlez pas, votre sort s'améliorera. » Le mari de Nasrin, qui est lui-même avocat, dit aujourd'hui « C'est faux. Au contraire, le sort de cela s'est encore aggravé. Tout ce qui peut aujourd'hui sauver mon épouse, c'est la pression internationale. » Nous sommes en train d'essayer de convaincre les mairies, les municipalités en France d'installer son portrait géant sur les façades des hôtels de ville. Ça va être le cas, je pense, ce soir ou demain dans ma ville, à Rouen. Ça va être le cas à Nice. C'est déjà le cas sur la mairie du 16e arrondissement à Paris. Ce sera probablement le cas à Lille, à Lyon, à Marseille, peut-être à Bordeaux. En tout cas, nous essayons de convaincre les maires, un par un, d'installer son portrait. Et si ce mouvement perdure, s'il prend l'ampleur que nous espérons, il est évidemment certain que cette chaîne de solidarité aura une ampleur parce qu'elle sera largement relayée par la presse. J'espère que vous, amis genevois, parviendrez à convaincre les autorités genevoises d'installer aussi son portrait. Le CNB a négocié les droits de la photographie avec l'Agence française de presse, de sorte que les barreaux peuvent utiliser librement cette photo que vous pouvez demander au Conseil national des barreaux. L'Ordre des avocats de Genève peut également installer son portrait sur sa façade. Toutes ces initiatives sont extrêmement importantes. Faut-il aujourd'hui, et la question posée par le bâtonnier Morer est essentielle, faut-il aujourd'hui réformer la déclaration de la Havane? Cet instrument, vous le savez, n'est pas contraignant et on peut le regretter. On peut considérer, et ça nous est rappelé parfois, que ça n'est qu'une déclaration et qu'elle n'engage pas véritablement les États. C'est vrai. Et je dois vous avouer que pendant un temps, je m'étais dit qu'il serait peut-être intéressant d'initier une réflexion sur l'adoption par les États membres de l'ONU d'un texte plus contraignant. Et j'ai compris que malheureusement, je dis bien malheureusement, il ne fallait pas emprunter cette voie parce que tout laisse à penser aujourd'hui que majoritaires seront les États qui décideront de renoncer aux règles de la Havane ou d'adopter des règles qui seront en deçà de celles dont nous disposons aujourd'hui. Une renégociation en vue de l'adoption d'un instrument plus contraignant serait malheureusement, c'est triste à dire, mais probablement extrêmement dangereuse, voire contre-productive. La solution, défendue notamment par notre confrère Laurent Petiti, consiste probablement à faire la promotion de la Convention européenne sur le statut de l'avocat, qui est en négociation, qui j'espère sera prochainement adoptée et qui sera ouverte ensuite à la ratification de tous les États, y compris les États hors Europe. Ce sera une convention à proprement parler universelle et nous espérons alors que nombreux sont les États qui la ratifieront. Voilà les quelques explications que je voulais vous donner. Il y a matière à être pessimiste, c'est vrai, parce que je pense que la répression des avocats, comme je vous le disais, est de pire en pire. Mais nous ne devons pas cesser ce combat, parce que ceux de nos confrères qui se battent le font avec un courage qui confine à l'abnégation, qui les honore, qui honore le barreau en son entier, parce qu'une atteinte portée à la défense, où que ce soit dans le monde, est une atteinte portée à la défense en général. Nous devons donc plus que jamais être à leur côté, travailler toujours ensemble, unissons nos forces, continuons comme nous le faisons au sein de l'Observatoire international des avocats en danger, à joindre nos compétences. Cet observatoire, vous le savez peut-être, a été créé par le Conseil national des barreaux français, le barreau de Paris, le Conseil national italien et le Conseil national espagnol. Et il a comme membre très actif, et nous en sommes très heureux, le barreau de Genève, le barreau de Madrid et d'autres barreaux encore. Des villes, des régions sont également membres, des syndicats, des associations d'avocats. Faites la promotion de l'Observatoire. Le rôle du barreau de Genève, je suis heureux de le dire, j'allais dire ici, non, je ne suis pas ici malheureusement à Genève, mais je suis heureux de le dire devant mes amis genevois. Nous sommes vraiment très très heureux de la participation, d'une grande efficacité et d'une grande générosité du barreau de Genève, avec lequel nous souhaitons continuer à travailler main dans la main, et l'organisation de cette journée en est la preuve. Je vous remercie beaucoup pour votre attention. J'espère ne pas avoir été trop long. Et merci encore pour votre invitation.
Thank you, Sedillo. We are running a bit late, but maybe if we could take at least one question from the audience or from Zoom. As of now, we have no questions online. We have one question here. Could you please use? Yeah, thank you.
Merci Adrien. Philippe Curat, je voudrais poser une question à Richard Sedillo et à Pascal Morer, et vous me permettrez de le faire en tant que président du conseil de la Fondation Martin & Hals pour les défenseurs des droits humains. Chaque année, la Fondation remet 3 prix à des lauréats qu'ils sont distingués par un jury international composé des 10 plus importantes ONG, dont Amnesty International, Human Rights Watch, la FIDH, l'OMCT, la Commission internationale des juristes, pour n'en nommer que quelques-unes. Et depuis 25 ans, nous avons régulièrement distingué des avocats, dont en 2012, Nasrin Sotoudeh, Richard, que tu as mentionné à plusieurs reprises, très justement. Cela signifie que notre jury considère que nous sommes des défenseurs des droits humains et c'est une bonne chose. Il existe évidemment d'autres prix spécifiques aux avocats. On a mentionné le prix Ludovic-Trarieux. J'aimerais savoir quelle est votre évaluation de l'importance de ces prix pour permettre à nos consoeurs et à nos confrères de poursuivre l'exercice de notre profession d'une part et pour participer à assurer leur sécurité lorsqu'ils le font sur des terrains où nous sommes particulièrement exposés d'autre part. Je vous remercie de vos interventions.
Thank you, Maître Philippe Curat.
Bon, comme personne ne prend la parole, je vais parler le premier. C'est extrêmement difficile de répondre à ces questions, mon cher Philippe, parce que il y a des exemples contradictoires. Alors, je prends le prix Ludovic-Trarieux. Le prix Ludovic-Trarieux, en 2016, a été décerné à une avocate chinoise, Wang Yu. Wang Yu était en détention. Elle a obtenu sa liberté à la condition de renoncer au prix Ludovic-Trarieux. À cette occasion, on s'est dit, on sert vraiment à quelque chose. Elle n'a pas renoncé au prix Ludovic-Trarieux publiquement en disant que c'était grâce à ça qu'elle avait été libérée. Elle a été libérée et dans une intervention publique, elle a dit qu'elle renonçait au prix Ludovic-Trarieux. Nous nous sommes enorgueillis du fait qu'on y était peut-être pour quelque chose. Là, c'est un exemple positif où on peut se dire que les prix internationaux, les reconnaissances que l'on a pour les confrères qui sont sujets à du harcèlement ou à des tortures ou à des menaces vaut quelque chose. Nasrin Sotoudeh, elle a été reconnue par toutes les organisations internationales d'avocats, par les associations nationales d'avocats. On a réussi à l'aider. Elle a eu le prix Ludovic-Trarieux en 2018. Elle est à nouveau en détention. Et je pense à une jeune femme que j'ai rencontrée extraordinaire, une avocate égyptienne qui s'appelle Mayenour Al-Masri. Mayenour Al-Masri a eu le prix Ludovic-Trarieux, elle a été soutenue par l'Union internationale des avocats. Je l'ai rencontrée, je crois que c'était à Bologne. Elle a pu venir prendre son prix en personne, ce qui est assez rare, parce que souvent les lauréats ne peuvent pas se déplacer. Et il y avait un cocktail après la réception. Elle est venue au cocktail et je parlais avec elle, une jeune femme, toute fine, toute svelte, une détermination hallucinante. Et je lui ai dit, mais vous voulez manger quelque chose ? Elle a dit, non, je suis à la grève de la faim pendant ma détention et j'arrêterai la grève de la faim quand mes collègues seront sortis de prison. Devant cet exemple extraordinaire de détermination, on se dit qu'on lui a redonné du courage. Et elle est repartie. Aujourd'hui, on est en train de la soutenir. Elle est de nouveau en détention en Égypte. Il y a une action de l'Union internationale des avocats en cours pour venir à son secours. Alors, est-ce que l'on sert à quelque chose ? Est-ce que l'on ne sert pas à quelque chose ? Ça, c'est une question qui, quand je pense au travail que j'ai fait avec d'autres, parce que c'est un travail qui est ingrat, ça demande un travail de veille permanente. Il faut récolter les informations, il faut constituer les dossiers, il faut préparer les lettres. Dans nos organisations, il faut avoir des départements spécialisés pour faire ça, parce qu'une organisation nationale ou internationale, comme le disait Lady Kennedy, a d'autres préoccupations souvent et d'autres activités. C'est décevant parfois, c'est frustrant. Ça nous donne l'idée que s'il y a un cas qui sert à quelque chose, ça vaut la peine de continuer. Mais savoir si ça sert ou si ça ne sert pas, j'ai jamais eu la réponse claire. La seule chose que je sais, par contre, c'est qu'on peut avoir une influence sur les barreaux. Parce qu'il y a de plus en plus de barreaux dans le monde qui ne sont pas des barreaux indépendants, qui sont des barreaux qui attaquent leurs propres avocats, qui sont des barreaux qui radient leurs avocats. Là, nous avons une influence directe parce qu'ils ont besoin d'une reconnaissance internationale. Et il faut, au niveau des organisations internationales, que nous fassions tout pour que ces barreaux soient pas reconnus et qu'on leur dénie leur indépendance. Là, nous avons une action directe, probablement. Voilà un peu ma position à ce sujet.
Thank you very much, Monsieur le bâtonnier Morer. I don't know if maybe Lady Kennedy, you want to have a few conclusive words. We have heard a lot of French. I don't know if you want to have a few words to conclude.
I just wanted to finally say that it's really important that we try to find ways of giving real teeth to international community outrage at the ways in which our colleagues in the law are treated. Not because we're a club of lawyers, but because we believe in the rule of law and because we believe in human rights. And so I'm strongly suggesting that we really do try to think through how we can bring some kind of purchase on the system. And I do think that we have to be prepared to demand targeted sanctions against those who really are responsible for example, the lead prosecutors in places like Turkey. I do think that we should be looking at targeted sanctions against ministers of justice. And if you know, countries did that, and we did that in coalition with each other and called upon our own nations to do it, then it wouldn't necessarily always happen, but it would make those people frightened about their responsibilities and duties, and make them perhaps be more reflective before they make these arrests possible and these prosecutions possible. We have to create an intolerance of this kind of behavior. It has to be zero tolerance for the attacks upon the judiciary and upon judges and upon journalists who are doing their professional roles. So I think sometimes we get comfort from coming together and sharing experience and stories, but we have to take it further, because we've just seen a young woman lawyer die in Turkey, and there's a woman dying in Iran just now, and our outrage has to be felt.
Thank you, Lady
So,
Kennedy. And so on these conclusive words, we are gonna give speech to Maître Saskia Didisheim for the presentation of our next speaker.
And it's the time now for the conclusion, and it's the good time for me to introduce François Imre. He's the perfect person to get the conclusion of this very rich and moving day. He has such a rich career. He was mayor at 28 years old, then deputy, then diplomat. He was ambassador for France for human rights. And he was telling me, just chatting outside a little while ago, that he did like 130 missions and all over the world over 4 or 5 years. And that sometimes, often, the key of the solution of all the problems that he encountered was the authorities. And then he was ambassador for France and Denmark, and now he opened a law firm in Paris, and he working with some Geneva lawyers for the case of Tariq Ramadan, as we were just talking. But so welcome, François, in Geneva. And I was as well very moved to talk to him because Lydiane Ayoum, who was a Cameroonian lawyer that was in prison for 7 years, that I have defended, and she told me so much about François. François was big, he was the one who just triggered the freedom of Lydiane, and I was very happy to meet with him just now. So welcome, François.
Monsieur le bâtonnier, mes chers confrères, merci pour ces mots, merci pour cette évocation. C'est un grand privilège pour moi d'être invité à clôturer cette journée. Et vous le sentirez certainement, quand je dis que c'est un privilège, ce ne sont pas des mots convenus d'un ancien diplomate. Et je voudrais, si vous le permettez, partager avec vous 2 ou 3 réflexions que m'inspire cette journée et ce que nous avons entendu. Ces témoignages que je vous remercie d'avoir recueillis et qui nous montrent l'actualité de ces principes de base et qui, pour moi, rappellent d'autres témoignages, d'autres missions que j'avais effectuées. Vous avez gentiment mentionné certaines d'entre elles dans les zones de conflit et partout dans le monde où règne une forme de tyrannie, partout où la Déclaration universelle des droits de l'homme est invoquée, mais où ces articles et ces principes sont constamment violés. Durant ces 5 années, j'étais très souvent en contact tout le temps de victimes de torture, de viols, de disparitions forcées, des femmes souvent, des enfants parfois. Mais partout, j'ai vu des avocats en première ligne et partout, j'ai vu que les avocats étaient les premières cibles. Je me rappelle en particulier de cet avocat que le ministre à l'époque, Bernard Kouchner, m'avait demandé d'aller voir, ou plutôt d'aller soutenir durant son procès au fin fond du Kazakhstan. Et je me rends à Almaty en voiture dans le pays. Et là, je ne le trouve pas parce qu'il n'était pas autorisé à sortir de sa cellule pour assister à son propre procès en appel. Je me souviens de Stanislas Markelov, qui a été abattu le 19 janvier 2009, avec Anastasia Baburova, 24 ans, dans les rues de Moscou. En Tchétchénie, de cette femme formidable qui me montrait avec passion ces dossiers de la Cour européenne des droits de l'homme. Elle n'était pas encore avocate, mais quelle défenseur elle était, Natalia Estemirova. Et en allant la voir là-bas, je pensais réellement la protéger. Quelques semaines après, on a retrouvé son corps dans une forêt. Je me souvenais aussi de ce que m'avaient dit des enfants de moins de 15 ans, découverts au fond d'une oubliette, sous une annexe du palais de justice de Kinshasa, qui n'avaient pas mangé depuis 6 jours. Et ce qu'ils m'avaient demandé, c'était à manger, à boire et un avocat. Eh bien, quand je pense à tous ces témoignages, à ceux que nous avons vus aujourd'hui, dont je disais tout à l'heure, ils nous rappellent l'actualité de l'enjeu, et puis ceux que j'ai vécus personnellement, c'est le portrait robot de l'universel qui se dessine. Et me viennent en mémoire les mots de la genevoise Jeanne Hersch, qui disait des droits de l'homme et des droits de l'homme universels, qui les définissait comme une exigence fondamentale que l'on ressent partout. Et c'est ça que l'on sent aujourd'hui dans cette journée. Les droits de l'homme universels, ce n'est pas un concept abstrait de juriste ou de philosophe comme Jeanne Hersch. Si les droits de l'homme sont universels, c'est parce que l'homme est universel, parce que les agressions sont universelles et l'oppression est universelle, mais le besoin de justice et de dignité est universel. Et cette universalité, inscrite dans le seul texte, d'ailleurs, qui la revendique dans son titre, l'universalité de la Déclaration universelle des droits de l'homme, elle est aujourd'hui en danger. Elle est aujourd'hui menacée. Qui aurait pu croire que la notion de famille humaine proclamée le 10 décembre 1948 comme la plus haute aspiration de l'homme, disait René Cassin, soit aujourd'hui en recul, débattue, contestée à quelques mètres d'ici, au Palais des Nations, et également à New York. Je l'ai vécu personnellement. Je crois au symbole, et cet anniversaire des 30 ans des principes de base coïncide aussi avec l'anniversaire des Nations Unies. Et Genève est le symbole aussi de cela. 75 ans, c'est un âge raisonnable pour le bilan. C'est vrai pour une personne, mais c'est vrai aussi pour les États et les institutions. Combien de textes adoptés, signés, ratifiés, mais pas appliqués? Eh bien, le rôle de l'avocat, c'est précisément cela. C'est transformer l'idéal invoqué par ces textes en réalité quotidienne, transformer les droits de l'homme en droit. Je connais parfaitement les faiblesses du système multilatéral. Et je voudrais en dire un mot parce qu'on ne peut pas évoquer les 30 ans des principes de base sans évoquer leur naissance et ce creuset de droits qui sont souvent invoqués et rarement appliqués que sont les Nations Unies. Je connais les faiblesses de ce système, les déceptions, les renoncements et la tentation par conséquent d'abandonner ou de reculer sur le multilatéralisme, ce qui a été construit ici et ailleurs, notamment depuis la Seconde Guerre mondiale, mais ici depuis la Société des Nations. Mais nous vivons dans un monde particulièrement imprévisible, qui, au moment de l'adoption de ces principes de base, ou même du 20e anniversaire, aurait pu prévoir les printemps arabes, l'Ukraine, la Syrie, le Brexit, l'élection américaine. Nous croyons savoir où nous allons, et nous ne savons pas. Nous croyons connaître notre monde, et nous ne le connaissons pas. Et ces incertitudes, pour le diplomate, sont autant de dangers. De danger pour le monde, de danger pour la paix, de danger pour le droit et pour la sécurité. Et je crois qu'il faut, malgré toutes les insuffisances, malgré les déceptions, réaffirmer notre attachement au multilatéralisme. Il faut le faire sans naïveté, sans se payer de mots. Bref, soyons capables de condamner les manquements des Nations Unies au nom des valeurs de la Charte des Nations Unies, mais pas de condamner les Nations Unies au nom de ces manquements. Mes chers confrères, l'avocat, par sa mission même, il porte une part de cet universel. On peut s'interroger sur l'utilité de ces célébrations et de la célébration solennelle dans le monde de ces principes et de la solidarité. Encore qu'après une journée comme celle que le barreau de Genève a organisée, on s'interroge moins. Et personnellement, quand je doute de tout, je ne doute pas de l'utilité de cette solidarité entre avocats. Et vous avez, et je vous en remercie, évoqué le souvenir de Lydia Neyum, cette confrère que j'étais allé voir et, je crois, aider à sortir de prison au Cameroun, un exemple de détention arbitraire. Comment oublier les chaînes, comment oublier les rats? Et je me souviens qu'elle s'était maquillée pour me recevoir dans cette univers qui était le contraire de ce que la dignité humaine peut évoquer. Et elle m'avait dit ceci: votre visite, votre démarche, ça m'aide à tenir. Eh bien, aider à tenir, aider le monde à se tenir et à se tenir droit, c'est notre mission et je n'en connais pas de plus haute. Je vous remercie.
So this is the conclusion of our today's event. We would like to thanks very much all the different panelists who took the time to speak with us today, and for the ones who were present as well, and for all the people in the room and who attend. So we are very honored to have organized this event, and we thank you very much again.